You have in here some quotes from a brief that Elman wrote in, I think it was the Henderson case. And I must say that that is among the most beautiful writing that I have ever read in a brief. And you know, the point always was that he was a fantastic writer, absolutely a fantastic writer. Would you mind reading the bottom of page 2 and the top of page 3, which is what you're quoting here is from what Elman wrote. And this is 65 years later or so. And yet, you know, this says it all as to what had to be said in those days, and nobody else is really saying.
This appeared in the brief that you're talking about in Henderson against the Interstate Commerce Commission, which is a 1950 case.
Right.
And I think it's accurate to say that it was the first brief filed by any party in front of the court since Plessy that squarely and directly asked that Plessy, which was the case that stood for separate but equal, that case be reversed.
That was 1896.
That was an 1896 case.
Yeah.
And so it was the government in Henderson, and it was Phil writing the brief.
Yeah, because he could, a gentleman couldn't eat in the, as I remember, he couldn't eat in the dining car.
This was a government employee who was an African American who was denied service in a dining car because the table at which he would have sat was occupied by whites.
Right.
And there was a curtain, and he went back to his dining car. He went back from the dining car having not been served. He later brought a suit. The case was extraordinary because the Interstate Commerce Commission responded by saying that those are, you know, separate but equal is a policy of and the Commerce Commission supports the policy, and it is the law of the country. And they won below, and they won at the appellate level, and then it came to Phil's desk. And Phil looked at this and he said, "This is wrong. This is just not right." And he convinced his superiors to that they should confess error. We'll talk about maybe confession of error.
Well, for the layman, that means admit that we were wrong all the time and rule against us.
Yes, so here the Interstate Commerce Commission had won below, and now it gets to the Supreme Court, and the Supreme Court's, the lawyer for the government says, no, we're not going to argue that in the Supreme Court. And so the ICC had to argue it itself, and Phil, representing the Solicitor General, wrote the brief, and the brief said, segregation of Negroes, as practiced in this country, is universally understood as imposing on them a badge of inferiority. That type of segregation imposed by the railroad's regulation is humiliating to those subjected to it. That it is so obvious as scarcely to need documentation. This message of humiliation comes not as a single voice, but with all the reverberations of the entire pattern of segregation and discrimination of which it is part. It's bad enough for the Negro to have to endure the insults of individuals who look upon him as an inferior. It is far worse to submit to a formalized and institutionalized enforcement of this concept, particularly when, as in this case, it carries the sanction of an agency of government.
That's probably the finest writing I've ever read in the civil rights field. And it was among the earliest.
Yes, it was.
Yeah, I mean, that's amazing stuff. That's amazing stuff.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu. Welcome